Ladies and gentlemen, welcome. We're going to call this meeting to order. We're calling ourselves the Reapportionment Subcommittee, and we're all members of the Corporations, Elections, and Political Subdivisions Committee. And we formed a subcommittee to come over here and have a hearing with you guys. So let's start by calling the roll. Thank you, Heather.
Senator Boner.
He's excused. My understanding he'll be here shortly.
Senator Steinmetz here. Representative Johnson.
Johnson? He's definitely present.
Representative Weber. Here. Co-chairman Knapp.
Here.
Co-chairman Case.
Present. Thank you very much. So everybody, my name's Cale Case. I'm from over in the center part of the state. I'm from Lander, but my daughter-in-law is from Newcastle, and she's a very nice person, I will say that. And my family homesteaded down at Lost Springs. That's where my grandparents. So would anybody else like to introduce themselves? I know you know some of these characters, so let's go to my co-chairman.
I'm Representative Knapp. I'm from District 53, which is over in Gillette.
Hello, everybody. I'm so happy to be here. I am Nina Weber, representing House District 24 in Cody. And I can tell you, it is a long way to this side of the state. Anyway, beautiful drive, nice little town, and I saw so many antelope jumping around being really stupid.
Well, hello everyone. I think you know me, but I'm Senator Steinmetz and I represent this part of the southern part of Weston County and Goshen and Niobrara. So it's good to see so many of you here, and my colleague Representative Williams, who we ran this bill together, and also our speaker, Representative Nyman, is here, and yay! Senator Boner made it through road construction, so I was only a little ways ahead of him, so we all made it. And we're glad to be here, and I think we're introducing ourselves, Senator Boner.
Go ahead, Senator.
Well, just in time, great to be here. Sorry I was a little late, but you know, it's busy sorting sheep, and then had some road construction come up here. So yeah, good to be here. Certainly was on this committee last time we did redistricting, and looking forward to hearing the perspectives and concerns that we have in this community. And so yeah, thanks for hosting us, and glad to be here.
And then let's go online to Representative Johnson.
Thank you, Mr. Chairman. I'm Steve Johnson, representing House District 8, and I'm in South Dakota on a pheasant trip that we planned before we scheduled this meeting. So I'm zooming in to help everybody in my district, and let's do the right job. Thank you.
You shouldn't have gone over there. I passed about 30 pheasants on the way over. Let's hear from our staff. Mr. Obrecht, would you introduce yourself?
I'm Matt Obrecht. I work for the Legislative Service Office in Cheyenne.
Hi, I'm Heather Hunter, and I work for LSI in China.
So Mr. Obrecht is being very understated. He's the director of the Legislative Service Office, and he came up through the ranks. And in fact, he staffed the Corporations Committee, Corporations, Elections, and Political Subdivision, and we've been through redistricting efforts together on many occasions, and I specifically asked that he come and help us to work through all this. So the reason that we're here is because in the last session of the legislature, there was a bill passed called Constitutional Apportionment. It was actually Constitutional Apportionment 2. It was carried by Senators Driscoll, Cooper, Dockstader, Hicks, Larson, and Steinmetz, and then and also by Representative Wharf and J.D. Williams here. So the bill provides that the legislature should take some time to come over here and listen to you, basically, and to listen to your concerns about representation and redistricting. And so I think, you know, that's the reason we're here. It has the bill does have some specific findings. I don't know if, Mr. Olbrich, if you want to lead us through that at all, just to make sure we touch all bases.
You bet, Mr. Chairman. So the first item after your agenda and your packet of materials is Senate File 174, being Senate Rolled Act 73. And Mr. Chairman, as you mentioned, Section 1 of the bill starts with findings. The people of Wyoming did ordain and establish the Wyoming Constitution. The Wyoming legislature derives its powers from the Constitution, and its acts must be conformable to it. Article 20, Section 1 of the Constitution provides that the Constitution may be amended and specifies in what manner. On page 2 at the top, subsection 4 provides that the apportionment provisions of the Wyoming Constitution are quite clear, citing to a Wyoming Supreme Court case. Paragraph 5 provides Article 3, Section 3 of the Wyoming Constitution. Each county shall constitute a senatorial and representative district. The Senate and House of Representatives shall be composed of members elected by the legal voters of the counties respectively. Every 2 years, it shall be apportioned among the said counties as nearly as may be according to the number of their inhabitants. Each county shall have at least one senator and one representative, but at no time shall the number of members of the House of Representatives be less than twice or greater than 3 times the number of members of the Senate. Paragraph 6 quotes Article 3, Section 48. At the first budget session of the legislature following the federal census, the legislature shall reapportion its membership based upon that census. Notwithstanding any other provision of this article, any bill to apportion the legislature may be introduced in a budget session in the same manner as in a general session. What that last sentence or provision provides is that it doesn't need the 2/3 introductory vote. On the top of page 3, paragraph 7 says, since 1992, the Wyoming legislature, contrary to the Wyoming Constitution's apportionment provisions, has allowed for the creation of legislative districts that do not follow county lines and legislative districts that do not have at least one representative and one senator per county. Apportionment for the Wyoming legislature must also conform with the Equal Protection Clause of the 14th Amendment, under which the overriding objective is that the vote of any citizen is approximately equal in weight to that of any other citizen in the state. Paragraph 9, conformance to both the federal and state constitutions may be best achieved with a legislature of manageable size. 10, no inconsistency exists between requirements of Article 3, Sections 3 and 48 of the Wyoming Constitution and of the Equal Protection Clause of the 14th Amendment of the U.S. Constitution. And the Wyoming legislature must comply with both constitutions in apportioning for legislative elections. Section 2, the legislature finds that the legislature shall make a good faith effort to apportion itself as required by the 14th Amendment in conformance with the principle that a vote of any citizen is approximately equal in weight to that of any other citizen in the state. And the legislature shall make a good faith effort to apportion itself as required by Article 3, Section 3 and 48 of the Wyoming Constitution by providing for legislative districts that follow county lines and legislative districts that have at least one representative and one senator per county. Section 3 is how you all got here today. The Management Council of the Wyoming Legislature shall assign a committee of the legislature to study apportionment of the legislature as provided by this act during the 2025 interim. The assigned committee shall conduct meetings in communities around the state to take input on apportionment options for members of the public and other interested stakeholders and report its findings to the legislature no later than December 1, 2025. The committee, and probably that means the full joint corporations committee or management council, may introduce legislation to constitutionally apportion the legislature for introduction in the 2026 budget session.
Thank you very much, Mr. Director. Any questions for the director at this point? I do appreciate that. Thank you very much. So my understanding is that we have public comment online at this point. I understand that Secretary of State Gray wishes to make public comment, and then there's another gentleman online.
Hello.
Hi, Mr. Secretary, welcome.
Yes, very, appreciate it. Just for the record here, I am pulled over. My plan was to comment as the meeting progressed, Mr. Chairman. I do have some prepared comments, but I wanted to go through the agenda and had some comments once we saw the different proposals. I didn't really have any comment on the enabling legislation.
Fair enough. We had you listed, but we have you listed in both places. So if there's no questions for Mr. Secretary at this time, hang tight and we'll follow up with you a little bit later. And how about?
Thank you.
Is Mr. Correnti? Is he online?
He is, I promoted him, he's coming on now.
Okay. He looks a lot like Representative Johnson, actually. Mr. Grant,
Somebody,
go ahead.
thank you, Mr. Chairman. Kind of in the same posture as Secretary Gray. I didn't think I'd be speaking till later, but I do have comments that I can contribute now, and then I'll send you guys written notes if necessary. But I've looked over all the materials. First of all, I'm Joey Correnti, a former chairman of the Carbon County Republican Party, also the former chairman of the Wyoming Republican Redistricting Committee. And I've been either observing or involved in redistricting for the past 2 cycles since 2012. When I did look over the meeting materials, I really didn't find myself being in favor or against any given proposal that was presented, but I did have several concerns that are more procedural or constitutional related. Firstly, the posture that kind of brings us here. I agree with our state constitution says one thing and we have a footnote that has us doing something else, but the sentiment I've gotten is the posture of the county integrity within legislative districts being concerning. And it's definitely a legitimate concern amongst the people, recognized the Wyoming Constitution. But what I see happening is it presenting potential eventuality of revisitation of all the efforts we're currently engaged in once county-specific districts are potentially established, and then we get a lot of community interest complaints that come after that. I could see in pretty short order the posture of our county isn't represented by the current process because of the population density in another county within our district, pretty quickly evolving into our community voice isn't represented by the current process because of the population density in another community within our own county. So I think what we really need is a really holistic, comprehensive idea of the postures, the constitutional provisions. I'm not going to get into a lot of the court decisions, but I do know that we have some Wyoming Constitution specific focuses that probably need to be addressed. Pointed out in the constitutional consideration memos from Director Albrecht, Article 3, Section 25, this would be a concern with weighted voting. The vote required to pass a bill would, that provision of the Constitution would probably have to be amended to either be much clearer to expressly allow for it, or much more ambiguous to leave kind of the unidentified possibility for that practice of weighted voting. Because it does specifically state all the members elected to each house. Another section that wasn't mentioned in the memo, Article 3, Section 11, even constituting a quorum, the specific passage from the Constitution says, a majority of each house shall constitute a quorum to do business. It's not clear under weighted voting whether that would be individual members or the weighted vote presence versus the weight of the total chamber. So again, when we get into weighted voting, not even taking on the considerations of you and your peers dealing with each other as equals, how that would all work out. I really see a lot of constitutional issues outside of specifically apportionment and redistricting. Another section of the Wyoming Constitution that brings up some concern right now, Article 3, Section 48, the state census that requires us to actually engage in reapportionment. The specific wording in that provision, the first budget session of the legislature following the federal census, the legislature shall reapportion its membership. And there's no clarifying language in that portion of the Constitution granting any relief from the mandate to do it or limiting it to specifically the decennial every 10 years census. Right now, we're facing a potentiality of having a mid-decade census. So if these constitutional concerns are not addressed through the process with whatever plan we come up with, if it's not fully considered across the Constitution, everything that's affected, we may be dealing with this sooner than we think, because our Constitution also states every time a federal census is done, regardless of when it's done, we will have a reapportionment of the legislature, or maybe a potential amendment clarifying that it's only during the results of the decennial census that we do reapportionment. I really hope that not getting on any specific plan for or against helps the committee adopt a posture that I'm really concerned about, which is the entirety of the Constitution being considered and bringing out language to address every issue for whatever plan we go forward with. The reality we're facing right now is that we could have another redistricting as soon as 2028. We may not be waiting till 2032 when the results of the 2030 census come in. So we really need to have those considerations, those proposals, and the constitutional amendments, I believe, ready to go for the 2026 general election so that they can be ratified in that election, because we don't know how soon we're going to be doing this again. The biggest problem I have with Article 3, Section 3 is the footnote. I understand it. I've read the law. I've read the legal precedent that's behind it. But what I really would like to see us do is get into a position where Wyoming does what the Wyoming Constitution says, and the Wyoming Constitution says what Wyoming does. Again, I'm not going to advocate for one plan over another on how we do it, but I think because each of you take an oath to your office saying, I will support and defend the Constitution of the United States and the Constitution of the state of Wyoming, it puts you in a little bit of peril when those two constitutions conflict and don't have clear language. We do have clear language. I believe it's Article 1, Section 20, maybe that reversed, but how the Constitution is amended. So if there is a legal challenge, if there is a court decision, I think that that should immediately trigger legislative action so that we can have our Constitution for the state of Wyoming fit the decisions of the court and the Constitution of the United States. So chiefly, I think that over the next few months, there needs to be a resolution to amend any of the articles of the Constitution, including Article 3, Section 3, Article 3, Section 11, 25, 48, whatever it be that is affected by the proposal and the intent going forward, so that there is some quantifiable good faith effort proven on the record, and future reapportionments can show that Wyoming does follow the state constitution and what it says, and the Constitution says clearly what Wyoming is going to do. I don't envy you guys in the task you're taking on, especially since there's a law that was passed that has a deadline date of December 1st, probably pushing you back to the next Corporations Committee meeting, so you really got maybe a month to figure this out, to satisfy the law and then bring it in front of Management Council or the entire legislature. So I know that's a tough job. I just really would like to see us take an effort to make sure whatever we're doing, it satisfies the intent and the requirements of the U.S. Constitution, and that may require something I'm not really fond of doing, making sure that the Wyoming Constitution is what we're doing. So beyond that, I don't know how many of you have been involved in redistricting before, other than the chairman and Senator Boner. But one of the things that will always remain, communities of interest, that will be a serious high-level consideration of any reapportionment effort. Those considerations affect things like Fremont County, Native and tribal communities, the South Greeley area, and of course my district, the largest district in America outside of Alaska, the rural 16,500 square mile district. Sometimes those communities of interest can be of more importance than being within a county line, knowing that the population center of your county seat is going to do what they want and have the representation. So again, something I hope that the committee contemplates. I know that's been a posture of the redistricting efforts in the past. Honestly, we're lucky with our population that we only have to focus on state legislative redistricting and don't have to deal with the federal congressional redistricting. As we go into these conversations and the redistricting or reapportionment shows up whenever it does in the next few years or in 2032, remember, no one works harder on or during redistricting than your LSO staff, so always make sure you're being appreciative of them. Lots of late nights and administrative work. And I might be a little remiss in saying this, but it's something I learned from Chairman Case quite a few years ago. Do realize that it is statutorily, constitutionally, and procedurally easier and a more straightforward process to change a county boundary than it is to change a legislative district boundary once the reapportionment plan has been adopted and signed into law. So you might hear some people out there saying the answer could be to realign the county boundaries or merge some counties to better distribute population and therefore representation. I don't know realistically if that's in the cards, but functionally it's already a clear and executable process that does exist. So with all of that, especially that last part, I just think we need to be very careful and considerate with what we're doing. And when we as a state end up changing or adopting a new posture for redistricting to satisfy all these concerns, the ultimate goal is to make sure that our state constitution reflects the process that we actually engage in. So with that, Mr. Chairman, I will give you back your committee and stand for any questions.
Thank you very much, Mr. Correnti. Any questions for Mr. Correnti? Seeing none, thank you. So it's, we haven't really done anything yet. So we do have on the agenda the history and principles of redistricting by Mr. Obrecht. But I would certainly, given we've already given public comment ability to Secretary Gray and Mr. Correnti, if anybody would like to make a public comment at this time, of course you can. You'll have plenty of opportunity later too, I promise you. We're going to take all public comment. Yes, sir.
Do I need to go up to the
Yes, you do. I'm sorry, because other people are looking at this online, and the only way that you can be heard and seen is to push the mic and speak into that microphone, sir.
And
Go.
keep it depressed while I speak?
No, you'll get a green light and you go with that.
Mr. Chairman, my name is William Curley. I'm a Weston County citizen. I just want to observe, these are preliminary matters, that as one of the authors, along with of sections 1 and 2 of SF 174, the reason that we focused in drafting those sections on apportionment provisions of the Wyoming Constitution is because we figured if we actually follow the state constitution, and as without amending it, maybe it needs to be amended, but if we actually followed it as it's now written, then the whole question of districting goes away. You don't have to redistrict anything. You just have to follow 3.3 that says the county lines are the district lines, leaving for consideration the issue of apportionment. And so I just came to mind while listening to the previous speaker, and it'll come up again, but I just want to share with you that I think the proper concept here where the committee's concern is apportionment. Thank you.
Thank you. Questions for Mr. Curley? Questions for Mr. Curley? Thank you, Mr. Curley. Anybody else, or should we let the LSO give us their take on the history of things? I'm not saying anything right now, and there'll be plenty of time, guys. So, Mr. Obrecht, would you take us to item 3, the history and principle of redistricting?
Mr. Chairman, under agenda item 3, Tamara Revelay, Legislative Counsel, and I provided the subcommittee with a memo on the history of legislative apportionment and redistricting in Wyoming. If we start on the bottom of page 2, since statehood until the 1960s, Article 3, Section 3 was followed in Wyoming with each county was given at least one representative and one senator. And then the extra representatives and senators were doled out in various mathematical formulas to try to give the larger counties more representation, more members in the legislature than the smaller counties. However, there was never any real equity among the population of those districts. And all of the members were elected at large from within those counties during that time. It all started to change in the 1960s. The federal courts started to recognize that the Equal Protection Clause of the 14th Amendment required that in state legislatures, the districts had to have equity among the population.
There is a tradition of Christian martyrdom. Charlie is not the first and not the last, and I think was probably aware that he could become a Christian martyr even in life.
Well, I would certainly categorize him as a martyr, but there's been martyrs ever since the cross. And the martyrs that went before us, they weren't clinging to religion or tradition. Neither was Charlie. Him and the martyrs that went before us, they were clinging to Christ, who had changed their life. So Charlie's boldness wasn't new. It's been happening for over 2,000 years. Evil has always tried to silence the truth. And if they think they can silence the truth by death, it has never worked.
To meet that equal protection standard guaranteed to the states through the 14th Amendment. So, the seminal case was Reynolds v. Sims, and that was based on Alabama reapportionment. And they had wildly different population among their legislative districts. The U.S. Supreme Court struck that plan down and said that that from henceforth all state legislative districts had to have roughly equal population to satisfy the requirements of the 14th Amendment. And this followed shortly on the heels of congressional districts also needing to adhere very strictly, even more strictly than state legislative districts, to the population requirements. And as this jurisprudence progressed through the years, kind of a prima facie case of constitutionality for state legislative districts developed, where if in either the House or the Senate, if the smallest district was no more than 10% smaller than the largest district, then your plan was prima facie constitutional. If you had a bigger deviation than that, than 10%, then the state bore the burden of proving under a strict scrutiny review by the federal courts that you met a compelling state interest. And really hardly any state could ever accomplish that. I think it's very rare now that there are any districts that are greater than 10% deviation. Hawaii's one in their House, and it's based on islands. And we're another one, actually, after our last redistricting. We've got some Senate districts that are, either close to or a little over 12% deviation, and that hasn't been challenged in court. And so, Mr. Chairman, that all came about for Wyoming. Starting in 1964, we actually had the Senate plan. Federal courts redrew the plan for the legislature, but then the legislature continued to redistrict along county lines following the 1970 census. In 1980, one of our plans even survived a direct challenge to the U.S. Supreme Court. It was a very narrow case, narrow holding based solely on Niobrara County. And then following the 1990 census, that redistricting or reapportionment plan was challenged in front of Federal District Court for Wyoming. Under Federal Voting Rights Act, those challenges are heard by a 3-judge panel of district court judges. So we had 2 district court judges and then our 10th Circuit judge sit on that case. And that is Gorin v. Carpin 1, where the court found in that case that the population deviations within that 1991 plan were too egregious and violated the Equal Protection Clause of the 14th Amendment. The court at that time gave the legislature the option to go back and reapportion based on the one man, one vote principle with not greater than 10% deviation. And if it didn't, the federal court threatened that it would redistrict for Wyoming. Wyoming did. The legislature come up with a plan. It was within that 10% deviation. However, the plaintiffs in the original case again sued, saying that plan actually needlessly split counties and needlessly split communities of interest. And the federal court in that case said, that's not for us to decide. That's purely a political question. And if it adheres to the equity of population, equal population, we won't disturb the state plan. And Mr. Chairman, in the 3 redistrictings following that, we have consistently redistricted with equal population within 10%, this last little minor blip being the exception. And we did, in the 2011-2012 redistricting bill, we had a challenge to that in state court. And the plaintiff's position, among other issues in that case, was that the plan needlessly split counties. And the Wyoming legislature was required by the Wyoming Constitution to come up with a plan that, while it adhered to the population requirements of the 14th Amendment, did not split any more counties than necessary when developing that plan. The district court judge, state district court judge in Cheyenne said no. After Gorin and Reynolds and the other controlling federal cases, the Wyoming Constitution does not provide that county lines have to be followed within redistricting, and that there is no provision that says that you can't split county lines more than necessary during the redistricting process. So, Mr. Chairman, that brings us to today.
Thank you. Thank you very much, Mr. Director. Questions from the committee for the director? Questions? Senator Barr.
Thank you, Mr. Chairman. I wonder if we can maybe go in a little bit more detail, the differences between Brown versus Thompson, which is the 1983 case that was upheld our more or less county-based redistricting plan. Then only 10 years later, all of a sudden, district court, federal district court can say, actually, that U.S. Supreme Court case is no longer relevant. We have to go by population. So it seems like a relatively short amount of time. And then there's also another element I don't quite understand. How can the 10th Circuit, kind of ignore the U.S. Supreme Court? I understand, as you said, it's very narrow, but maybe a little bit more detailed as to the interplay, what happened between the 1980 redistricting and the 1990 to produce such wildly different outcomes.
Mr. Director.
Mr. Chairman and Senator Boner, the Brown decision was so narrowly presented to the U.S. Supreme Court and based solely on the Niobrara County and not holistically into the whole plan at all, and whether that entire plan violated the equal protection provision of the 14th Amendment. The Supreme Court said that that the plaintiffs hadn't carried their burden of proving that one of their fundamental rights were violated by that plan. So the Gorin defendants learned, or plaintiffs learned then, that they needed to provide the entire plan, challenge the whole plan, not just what was perceived as maybe the most egregious provision of that plan. So that's what they did, and that's why the Brown decision wasn't controlling on the Gorin court.
Anybody else from the director? Anybody else? Mr. Director, Wyoming isn't the only state that's gone through this, of course. There's been many other situations in other states. And could you give me a flavor or give us a flavor for how those have proceeded? Is it only Wyoming that's covered by the 14th Amendment, for example? Or how have challenges in other states proceeded?
Mr. Chairman, and I don't have universal knowledge on what happens with other states, but I know this, starting with Reynolds, which was the challenge to the Alabama apportionment plan. The one man, one vote principle, as announced in that case, has been applied to all state legislatures. And every state legislature, maybe outside of Hawaii, and maybe only because of the unique island situation there, have required that if their districts aren't within 10% of the population of smallest to largest, then they're subject to a strict scrutiny review and likely to be found unconstitutional in the 14th Amendment. And Mr. Chairman, I think to your point, what I do know is after Colorado and Idaho's reapportionment plans were challenged in the 1960s, they amended their constitution to provide essentially what the plaintiffs in the 2012 lawsuit were alleging that Wyoming should do, and that is that they will not split county lines and other communities of interest if it's possible not to while developing a rational plan.
Okay, thank you, Mr. Director. Anything else for the director? I just said we're going to do the committee first, and then we'll open up to the public. Promise. Anybody else on the committee? Anything else? And Mr. Director, just in terms of trends, have there been more recent cases that go in any other direction? I mean, we kind of have new courts and new things. Is there any indication that there's a new way of looking at things out there?
Mr. Chairman, when we prepare after each census for our redistricting to be able to give advice to whatever committee and the full legislature, we rely on the National Conference of State Legislatures and the information they put out. And then we do our own review of cases that may be developing in that area. And as far as any movement by the federal judiciary away from the 10% deviation or requirement for substantially equal population among districts, I'm not aware of.
Thank you, Mr. Director. All right, let's open it up to the public that may have questions. Ask them through the chair, and we'll see. It's just kind of be like stump the LSL director. We'll see what we can do. But you're welcome. But please use the microphone. Come on up.
I'll wait.
That way you can correct me.
No.
Yes, ma'am. Go ahead. Welcome. Introduce yourself and tell us what your question is.
Mr. Chairman, I'm Tricia Bauman here in Weston County. And I would like to first, after hearing stories from Senator Driscoll about reapportionment and people's hair on fire, I would like to thank you for providing this nice calm venue to discuss this. And not being right after a census and taking the time to do research and talk to us. It's really appreciated.
Well, thank you. We look forward to coming here, we really did.
Good.
I'm actually, me and Johnson, we're the only ones that lost our hair in that photo. Go ahead, Ms. Bowman.
I'm certainly not an attorney, and I'm absolutely not the director of the LSO, but I do have a question about page 4 of the LSO memorandum, Chairman.
Go ahead.
There's a quote in there that says the U.S. District Court for the District of Wyoming recognized that such an outcome, and they were speaking about a large legislature, would not provide for a functioning legislative system, and directed the legislature to disregard the provisions of Article 3, Section 3. In my humble opinion, Chairman, the court in Gorin v. Carpin did not direct the Wyoming legislature to permanently disregard its state constitution and county line provision. The U.S. District Court for Wyoming found that the 1992 apportionment plan based strictly on county lines was unconstitutional under the U.S. Constitution. The court did not direct the legislature to disregard the state constitution. Instead, it ruled that when the state constitution provision conflicts with the federal, then the federal requirement must prevail under the supremacy clause.
The new store. This is the one-stop shop. We have a pharmacy. We have a bootlegger's liquor. The deli, the food that you can get at a lunchtime is so amazing. The coffee shop. Certain Friday mornings, there's 30 people sitting here in all these chairs. This is the hub for people to come and visit, have their coffee, have their donuts. It's amazing what this area has done. Totally amazing.
The court's language was about the practical impossibility of complying with both rules, given Wyoming's population distribution. A functioning legislative system in this context meant one that complies with both the U.S. Constitution's guarantee of equal representation and the state constitution. That'd be a functioning legislative system. The court, in my opinion, essentially said, you cannot follow your state constitution's county line rule if doing so violates the federal law. And it's my contention that there is the possibility, though I found no one who likes it, of having a huge legislature. It's possible. It can be done. And so our federal constitution and our state constitution are not in direct conflict. So the supremacy clause is out. And I believe in Gorin v. Carpin, they were just talking about the 1992 where they went strictly by county lines. And so I just like to point that out.
Thank you very much, Ms. Bowman. I thought about that a lot too. Certainly there is a way to reconcile the state constitution with the federal constitution in terms of having equal protection and also have county-based representation. But you'd have to start with Niobrara County, which is our smallest county. And it would be roughly, just say it's roughly, I'll make up some numbers. Let's say it's roughly 2,000 people. I know it's a little bit bigger than that, but roughly. And you compare that to our largest county, which is Laramie County, and I'm going to throw a rough number out that it's 100,000 people now. So you would want Niobrara County to have potentially 2 representatives and 1 senator, or you could do it by having equal sizes. You could do 1 representative and 1 senator. But that would mean that Niobrara County, if they had 1 senator, then Laramie County would need to have 50 senators. And then it would work. And it would have to play out across the state. I'm not sure about the deviations within each county, but it would be, it would roughly come together. So I agree with you totally. I think the court, the actual wording was that the legislature may disregard that section, realizing that this possibility of a very large legislature is workable. Mr. Director, I tried to give you time to think about that. And I was just waving my hand, so go ahead.
So, Mr. Chairman, my reading of that provision in Gore has always been that at the time, in 1992, the way that the population was distributed across the Wyoming counties, you weren't going to be able to achieve substantially equal population based on county line apportionment. If in the future, though, you could, if more people moved to Niobrara County and it would work or wherever we needed, then absolutely. But what the court was saying there, in my opinion, was you didn't have to, Wyoming legislature, you don't have to develop a plan with over 400 members, because that would be an unworkable legislative solution.
It's interesting they said that because New Hampshire has a legislature that's pretty much like that. And so, it's true. Back to you, Ms. Baumann, and then appreciate your question. If you had any final comment.
I agree with you. I was going to bring up New Hampshire myself, and I think maybe what this goes down to is the footnote under Article 3, Section 3, that basically the common man on the street reads and says, oh, we can disregard the Constitution. Yeah. And I don't believe that's what that court case said. It said, you cannot follow your state's constitution county line rule if doing so results in a violation of federal law. So it doesn't say disregard it. That would be my point, sir.
Thank you very much for that. We do appreciate it. Who else would like to play Stump the Director? Mr. Curley.
Let me stump the director.
It's pretty smart. Keep working at it.
Yeah.
Be sure and put the microphone on, Mr. Curley. Thank you.
Mr. Chairman, William Curley again. Thank you. I want to echo the comments Ms. Baumann opened with. Thank you all for the effort, the timing, the venue, the effort in coming up here. On the most recent issue, it's absurd to claim that a federal court can direct a state to ignore, legislature to ignore its own constitution. And I point out to you, we've been all over this at the beginning of the matter today, but one of the findings made by the legislature in SF 0174 is that the two constitutions do not conflict as to apportionment provisions. I think Ms. Baumann made that
Did your
point.
microphone go off, sir?
Yeah.
Sorry.
Yeah, there you go.
Now, I think that language of the famous footnote saying, taken to mean you can disregard, comes from a federal judge saying, get the H out of my court, will you please? It's been here enough. Remember that to even get to that posture, the court had already declined once to rule, had pointed out that the legislature was the right body to be making these decisions, and then it came back to the going court because plaintiffs sued again and saying, yep, the legislature took another shot, took another bite of the apple, but they didn't do it right. And so in that context, what you got is a federal judge saying, get out of my court, just satisfy my requirement under the 14th Amendment due process clause. But it's absurd.
Well, equal protection too.
Yes.
Keep going. I'm sorry.
Yes, thank you. Okay, so the issue, the overall issue, and maybe question I have regarding the LSO 10 September 2025 memorandum is that it seems to preclude consideration of weighted voting. It seems to assume that the only way to comply with one man, one vote requirement is through equally populous districts. But of course, that is not the case. In fact, the author of the LSO memorandum cites in footnote 22, 74 Buffalo Law Review 1, revisiting weighted voting, and suggests that that would be a useful source to review on that issue. The author is Professor Norman Williams, Director of the Studies of Constitutional Law at up in Oregon, Willamette, I believe, University. And I recommend that. Maybe we'll be able to offer that into the record too.
Sure, of course you can.
Thank you. In that article, he makes the point that, and directly affects something said here today, the cases from the 60s, 62, 63, and 70, and Mr. Ulbrich referred to them, there are cases from the 60s that say lower court cases, not Supreme Court cases, that say state legislatures can't do weighted voting. Now, I'm an author, along with Ms. Baumann, of a weighted voting plan that we're hoping you'll consider. The author of the article revisiting weighted voting points out that since those decisions, the Supreme Court of the United States declined to hear an appeal from a weighted voting case that in which the Second Circuit, goes one step down from the Supreme Court, Second Circuit upheld weighted voting. Now, this was at a New York County level. But the author makes the point that it's tough to be constitutional in one place and not constitutional in another. And since that case, Krause, which is referenced in the article, there was a 1994 Second Circuit opinion upholding weighted voting again, also at New York, where about half the counties to today have weighted voting. It is true that no state presently does have weighted voting, but that's not because it would violate the Constitution. Everyone says one man, one vote, and I just observed that the Wyoming Constitution 3.3 also requires district apportionment in accordance with population. So this isn't a strictly federal thing. Okay. Where was I going to lead? Well, now I lost that. Back to the apportionment. Okay, so none of the states have it, but I'm putting out for your consideration and compliance. Having read that article, reference to footnote 22, that there are other ways to comply with one man, one vote. And what that means is, and it's correctly pointed out in the LSO memorandum, it means that the vote of any citizen is approximately equal in weight to that of any other citizen in the state. It doesn't mean the district populations are approximately equal. That's a way to accomplish one man, one vote. But there's other ways. The plan that we've submitted, Ms. Baumann and I, would come up with a legislature roughly equivalent in size to what exists now. So that complies with the finding that perhaps it would be better to keep the legislature small. But it would be precluded from your consideration if the memorandum is taken to mean you can't do it. Thank you.
Thank you.
Right. Covered that. And I think that covered it. Thank you, Mr. Chairman.
Okay, so I think we're going to give you a chance to present the weighted voting approach. It's our next agenda item. We could just jump in there, but I think that some people might still want to address the committee. So hold tight, Mr. Obrecht. I don't know if you want to say anything at this point. Hold tight, Mr. Curley. Let's see about other public comment on the LSO memorandum, and then we'll go into local proposals, the proposals that we have, including the weighted voting, if that's acceptable. Who else would like to address the committee? Commissioner, how are you?
I'm great, thank you very much, Mr. Chairman.
Good to see you again. Welcome. Introduce yourself.
Thank you very much. My name is Marty Urban, and I had a prepared little speech, but I'm going to toss it to the wind because of the interesting way that we started this. So thank you very much for being here. I appreciate it very much for you to step within our boundaries, but I will throw a wrench right now. So in my investigation, and you know that I've been doing this for a long time, not as long as you have, I did keep most of my hair.
This is bad fire. Keep going.
In Abelwell versus Abbott in 2016, the most revered and most wonderful couple of Supreme Court justices, Justice Thomas and Alito, had concurring opinions, and the case was based on using population versus eligible voters. So there was a conversation of that, and it went to the Supreme Court. They did rule in favor of the population. But in the
Could you get that mic more pointed at you?
Sure.
I think everybody can hear you here, but
Sure, no problem.
some people actually watch this online.
Well, I would have been one of them.
Thank you.
No problem, and thank you for reminding me. So in the summation, what Justice Thomas' concurrence was, just in a summation, and I will have a quote, but Justice Thomas argued that there is no constitutional basis for the one person, one vote principle, stating that the Constitution leaves the choice of how to draw districts up to the states. Alito's concurrence was suggested that states are free to use different metric for apportionment if they choose, as long as it is not irrational. And I will give you a quote from Justice Thomas's concurrence. In my view, the majority has failed to provide a sound basis for the one person, one vote principle because no basis exists. The Constitution does not prescribe any one basis for apportionment within states. It instead leaves states significantly leeway in apportioning their own districts to equalize total population, to equalize eligible voters, or to promote any other principle consistent with a Republican form of government. The majority should recognize the futility of choosing only one of these options. The Constitution leaves the choice to the people alone and not to this court. And so I just want to throw that wrench in there, that there is a crack in this whole thing, and that if we can see a little light, and perhaps Wyoming can maybe put their finger in, or the door in the jar,
Something like that.
Maybe I should have something. But I just would like us to think about that. And like I said, I appreciate you allowing us to speak in our own county.
It's a delight. And just to note, that was a minority opinion. Did they join together or did they write separate dissenting opinions? Alito and Thomas.
They did not write it. I could not find a dissenting opinion, just a concurring.
Okay. Separate. Okay, I understand what you're saying. Thank you very much.
Thank you.
Any questions, Senator Boner?
Madam Chairman, sir, could you say the name of that case again?
Sure. Mr.
Go ahead.
Chairman, let me spell it for you because I may be pronouncing it incorrectly. It's EVENWEL Abbott, 2016. Thank you.
Thank you. Anybody else? Mr. Director, are you aware of that one? Care to comment? Go ahead.
Mr. Chairman, I think the commissioner accurately stated the concurring opinion in that case.
Okay. Thank you very much. Who else would like to just address at this time about the LSO memo? We'll have more public comment later, I promise. This is your last chance. And I do see that we've got a dignitary that's not getting into the side there. Speaker Nina. Welcome, sir. How are you? Good to see you. I missed you before and I apologize for that. Okay, anybody else at this time? All right, let's go into the next subject, which is to listen to your proposals. So we're all ears. Mr. Curley, you want to start? Ms. Baumann, you want to get up there and help? You guys have been burning the midnight oil, haven't you? Go ahead. Go ahead.
Well, you want me to start? Well, you were supposed to start because I was nervous and then you were supposed to slow me down.
That's a man for you. I always say that every day.
Yes. William Curley and I worked together trying to figure out how could we follow both constitutions, keep the legislature about the same size that it is now, and in addition, keep the power structure the same as it is now. So the voting strength on the floor from Laramie County right now is the same as the voting strength from Laramie County on the floor in our proposal. It does, as William alluded to, involve weighted voting. And we did put a handout on weighted voting if someone would like to look at that, but it basically reasserts what William discussed on revisiting weighted voting by Professor Williams. It's a quote from that, so that is in the record. We also did a second handout called Population of Legislative District and Voting Strength in the Legislature. And it's a short one. It says a direct relationship arises out of the different population sizes of Wyoming's legislative districts, counties, and the federal due process clause requirement that the vote of any citizen be approximately equal in weight of that of any other citizen. Currently, Wyoming districts are approximately equal in population. So their electeds have approximately equal voting strength in the legislature. To comply with both constitutions, we submit that constitutional districts, counties, with substantially unequal populations have electeds who have substantially unequal voting power in the legislature. This assures that each county is a district and that each district's electeds reside within the county of those voters they represent, and that each citizen's vote is approximately equal in weight to that of every other citizen. So our proposal is called Population Adjusted Legislative Apportionment. And William, do you want me to go through the whole thing? Or do you want to?
No, I wasn't going to go through the whole thing.
Right, so.
Just the highlights.
Just the highlights, okay. Okay, so this has been introduced into the record and copies provided. The introduction is basically what I just said. Page 1 is basically what I just said. So at the bottom of page 1 is definitions. We provided a voting unit. A House unit as 10,000 in population would receive a full vote. A Senate unit would be 40,000 in population would receive a full vote. These votes are scaled proportionally to the district's population, so therefore there would be 25% of a vote for 2,500 people in the House and 25% of a vote for 10,000 people in the Senate. It discusses equal participation, which according to the LSO memorandum was one reason that weighted voting was not accepted by the lower courts, was that voters or the legislators were disenfranchised in other areas that were considered non-voting legislative activities. In our proposal, all legislators have full right to participate in debates, bill sponsorship, committees, everything. So you are there fully participating, and the only time that you are weighted is in a floor vote. And then William and I spent several days trying to figure out a formula that you could use after every census. I don't need to probably go through that exact formula with you, but on page 2, number 4, what we came up with as a result of our formula is that in the House there would be 57.5 total weighted votes, 63 representatives. The largest district of Laramie would have 10 full votes, and the smallest district, Niobrara, would have 25% of 1 vote. Our point is the Niobrara citizens now have a person from their county sitting in Cheyenne, speaking for the commissioners of Niobrara, speaking for the courthouse of Niobrara, speaking for the citizens of Niobrara, but understandably can't put a lot of weight into the floor vote because their population is so small. In the Senate, it came to a conclusion of 14 total weighted votes by 27 senators. And I do have tables that show how that looks.
So, yes.
Number 5 is deviation. So people talk about the population equality, equal effective votes, and an allowable deviation of 10% in population. And William and I would like to look at a different type of deviation. So you would look at the percent of the state population that Niobrara has compared to the percent of vote they have on the floor, and try to equal those out.
Okay.
You want to add now? Okay,
Do that.
good.
Mr. Kirby, go ahead.
Mr. Chairman, thank you. I think Mr. Coretti and perhaps others have concerns that a plan such as I'm putting forward would have issues with certain parts of the Wyoming Constitution. I want to make 2 points on that. One, Wyoming Supreme Court has not opined on weighted voting for the legislature. Be interesting to see what they said. Under a state constitutional issue, it's not a federal issue. It's for our court in Cheyenne. And I wouldn't jump the gun and just start presuming they're gonna have a problem with this and a problem with that and a problem. Secondly, I'd like to, with the committee's permission, I will submit the full, it's just 2 pages documentation of the email exchange between myself and Professor Williams. But I would like to point out that in part of his response, the following, and I think it bears directly on our plan's consideration. The memo, meaning the 10 September 25 LSO memo. Mm-hmm. The memo is right, that lower federal courts struck down weighted voting schemes adopted by and for state legislature in the 60s in the wake of Reynolds v. Sims. But most of the article, meaning the professor's article, revisiting weighted voting, most of the article is devoted to discussing how some counties in New York continue to use weighted voting to this day, and how the U.S. Supreme Court upheld its use there. As the article explains, the federal court's rejection of weighted voting for the state legislature in the 60s cannot be reconciled with the subsequent cases after the 60s and early 70s, with the subsequent U.S. Supreme Court decision upholding its use for county commissioners, and that the reasons offered by the lower federal courts don't hold up today and wouldn't distinguish between state and county governments anyway. If Wyoming wants to return to a county-based apportionment system by adopting weighted voting, I do think it is constitutionally permissible. Though, in fairness, I would also add that the state is almost certainly going to be sued over it and have to defend it based on the arguments I made in my article. I have to concur with that. We live in a litigious society. We all know that. If it moves, it gets sued. I think, so what I'm indicating is I think that the matter will get in court, not because this plan or other weighted voted plan is a bad plan, constitutionally defective, but because it simply will be challenged by somebody. Also, our plan, on page 1 at the bottom, indicates the definition for a unit vote. And the House is 10,000, the Senate 40,000. Now, where did those numbers come from? In one sense, they came out of thin air because they work. You plug those numbers into our formulas, you get a House and Senate of about the size you have now. Now, New Hampshire presently has a House of 400 members, representatives, and 24 senators. Their House unit is roughly 3,300, and their House unit, Senate unit is roughly 57,000, I think. So those numbers, there's nothing written in stone about them. We suggest they're good numbers to use to get a decent sized legislature that we're used to. Also, ask you in considering weighted voting plans to always try to keep clear the difference, whose vote are we talking about? Are we talking about the vote of the citizen? Now that's how the one man, one vote mantra is explained. And again, that language is set out in the LSO memorandum, the direct quote from the Sims decision. The weight of every voter is approximately equal to that of every other voter of the state. But there's also the vote of the elected people, the reps and the senators in the legislature. And sometimes, and I think once or twice in the LSO memorandum, there's a bit of possible confusion as to which we're actually talking about. On our plan, all voting plans are weighted in some sense or another. All of them. Even if I'm the king, I get all the votes and you get none, that's heavily weighted in my favor. They're all weighted. 3.3 and 14th Amendment require that the vote of every voter be approximately equal to that of every the weight of the vote. Now, if the populations are equal, roughly, then the electeds from those districts will have roughly the same voting power. Our plan suggests that we adhere to 3.3. We have therefore districts that are not equal in population, not even close to being equal in population. Their electeds then will not have approximately equal voting strength in the legislature. The voters in the different districts, counties, will have approximately equal weighted votes. And you accomplish that because the districts are unequal population by having unequal voting strength of the electeds in the legislature. Anything else?
No, I guess I just want to.
That's your microphone, dude. Very good.
I guess I just want to reiterate that as we put this together, our goal was to keep the power structure of this plan as close as possible to the power structure that exists now. And there's case studies at the back of the proposal that I'm not going to go through them all with you. I would like to point out page 10 is the percent deviation in voting strength on the floor is a table C. And then there's an appendix with case studies. So I tried to take, right now you can't go by counties because the counties are split in the districts, but this is just a for instance, in the Senate, under our current system, Senator Steinmetz, Senator Driscoll, and the two senators in Campbell County, Troy McCowan and Eric Barlow, they currently have 4 votes out of 31 votes in the Senate. They each have a full vote. There's 31 senators.
Gotcha.
They have 4 votes in the Senate. So this is 12.9% of the vote. The Senate vote from those 4 senators have 12.9%. Under ours, if I go with the senator from Niobrara, the senator from Weston, the senator from Crook, the senator from Goshen, and the 2 senators from Campbell in our plan, and you put them all together, they would have 1.8 votes out of 14, and that's 12.86 of the vote on the floor. So 12.86 compared to 12.9 that you have now. And that was our goal. Thank you.
I see that. Any questions? Mr. Croce?
Thank you for the proposal. One question I had, you mentioned the vote on the floor. Do you anticipate that this would carry through in committee as well with the weighted vote coming out of committees?
Ms. Bond?
No, sir. I think that would apply under the page 2 equal participation clause in our proposal. So the only weighted vote would be on the floor, but you would have full power in committee to do as you're doing now.
Keep going. And I might ask, how do you establish a quorum on the floor?
That point's already been touched on in the very beginning. You'd be looking at you'd have to rethink quorum in terms of percentage of vote strength and not physical bodies. Because again, you don't have the equal population districts.
Understand. So it's funny, and operationally, we sometimes have to establish a quorum kind of quick. Sergeant of Arms usually does that. So they're like, they might be gathered around, but we don't have no people on the floor, so they're counting. And they're just looking at people and bodies and empty seats and trying to get people to fill them. Your way would be a little bit more complicated for the Sergeant at Arms or whoever does that, because it'd be more than just bodies. Keep going on this.
And I think without the advent of the computer age, we wouldn't be putting this plan forward for that reason.
Right.
But I believe the technological issues involved can be addressed so that it can be easily done quickly like that, because we'll begin to see, track, and display the weights for the people if the plan was adopted. May I add something?
You bet you can.
Speaking as one of the authors of the plan and as a Wyoming voter, the issue of minority in our state, Indian tribes, just speaking for myself, there are federal reasons why maybe even my plan, even though I think it's great, couldn't be strictly adhered to, possibly, depending on how the facts are on the ground and decisions are made on where to draw. districts. But if you follow county lines, maybe it will be an issue with tribes under federal law.
So that's actually my district. And
And so I just wanted that caveat, even I am saying that you might not be able to achieve 1,000% perfection. There's a couple other things that don't affect the state that much, but maybe they do with the tribes.
I'm just thinking out loud. The federal issue is that is the only potentially, it's called a minority majority, or majority minority, I might get it mixed. But it's where a minority population potentially makes up the majority of a legislative district. And so you need to pay particular attention to that, to not dilute their voting power. So what we did was create the Senate district and one House district that had the most Native American population possible. That is my district, actually. And so my district reaches into parts of Riverton, for example, that have a predominant Native American population. And it captures all the places on the reservation and elsewhere where Native American people live. And so that was done very, very deliberately. Now, if all of a sudden that representation were based on the county line, and then I presume that you'd be elected countywide, which everybody used to like a lot, they did like that, then there's a potential for that Native American strength in their voting to be diluted. So, and you're the one who brought it up, you made me think, that's what you're talking about, right?
That's what I'm talking about, and I'm not, is what I'm talking about, Mr. Chairman. I'm not trying to predict the future, that even my plan would have to be varied from, but possibly it could, and for good federal reasons.
Okay.
I'm trying to tailor the Wyoming legal issue for Wyoming courts, comply with our state constitution as a finding in the legislation, a finding that's already been made in as F 174, that the legislature exists because of the state constitution and the grant of power to it by the people, and it has no powers outside the grant. And the Constitution says what to do to abortion. So perhaps the fundamental line here, to correct me, you don't agree with this, is we'd like you to follow both constitutions. If you can't do that and have to amend the state constitution, which is one of the options mentioned in the LSO memorandum, then amend the state constitution and then follow it.
Okay, let's see if there are any more questions for me.
Thank you.
In addition to the weekly printed version of the newsletter journal, we also promote our community and share important information on our award-winning website, newslj.com, and in our weekly email newsletter, Nuke Now. We also connect with readers through various social media platforms and invite you to check us out on Facebook, Twitter, and Instagram. You can even take a look at a recent meeting of the City Council, School Board, or County Commission on our YouTube channel. We do hope that you will go to newslj.com and subscribe today, and we look forward to making all of our great content available to you. But regardless of your level of support, we thank you from the bottom of our hearts for doing your part to preserve a free and independent local press.
Committee? Senator Steinmetz, please.
Thank you, Mr. Chairman. And just since you brought that up with the tribes, and it raised another question for me, Mr. Crowley, and that is, or either one of you, whichever, but I'm just trying to wrap my mind around this proposal. So the bigger counties such as Sweetwater, Natrona, and Laramie would be decreasing in their number of representation. So how would you, if that's just based on county lines, then possibly the city, the urban population, would be able to elect all three of the senators. And there, right now, it's divided so that some of the more rural areas, like maybe Mills or some of the suburbs of Casper, are able to elect maybe a more conservative or someone more aligned with their values, But if they're all at large in Natrona County, what is to prevent Casper from, the urban center, from electing all of the senators or representatives? Is there something in the proposal to address that?
Mr. Curley.
There is not something in the proposal to address that. It's a realistic issue. I'll mention that New Hampshire deals with that issue in part by using what they call flotarial districts. We've tried it in Wyoming. It's been that you can have districts that are themselves divided. And that may aid in addressing that issue. It would be a sin against the creator to set up districts that are run entirely by urban folk.
Does it really say that? Wow.
It was in the margin of my book.
So if I can bridge her excellent point, you're saying that there might be room under the proposal to have sub-districts within counties.
Yes, the proposal would work if that method was adopted for use.
Okay. Does anybody else have questions? Are we doing okay, right? I have one that's just looking, I don't see any other questions, and I think Mr. Obrecht, we're gonna let him talk too sometime, but just in terms of the practicality, I get how this would work, and it's sort of, I can see how it's appealing. But let's go back to that example of Niobrara County, okay? Let's pretend like they ended up with one representative that had a quarter of a vote. Now, it's just an example, I'm not meaning it, it's just an example. So are they really better off that way? No. Because then the rest of the legislators don't really pay attention to them. That's right. Because there's only one person there that's beholden to Niobrara County. But they only get a quarter vote. So what happens when they go to Cheyenne, and how are they involved in making the things work or figuring out policy going forward? And how is Niobrara County better off that way rather than having different legislators, at least a legislator and a senator? And maybe if the county's split, they've got 2 senators and more. My point is, when you have more people that have a little piece of your county, you may not like it administratively because it's messy. But on the other hand, that's kind of a coalition that is working for your county on the right issue. And that can be very, very powerful. Help me with that, why that's worse than having, we're going to send John Smith to Cheyenne and he gets 1/4 of a vote. This is where I'm having trouble.
Mr. Chairman, I take that in 2 parts. One, if there are at times close votes in the legislature, are legislators willing to just ignore, blow off, be rude to, and guarantee the loss of all the quarter votes? Plus, you got other things working like civility, collegiality, common interest in getting something done for the state. Lots of reasons why it's not likely that intelligent legislators will just ignore somebody with a smaller weighted vote than they have. I think you touched on it. I just echo what you already said. It makes all the difference in the world to have someone from your county knows your school boards, knows your sanitation issues, knows your local hospital district issues, et cetera, talking for you and not having divided loyalties. That's got to be a hard job, representing more than if you take in Wyoming, generally speaking, a county to be the basic community of interest, then it's gotta be a hard job for a senator to represent more than one community of interest in Wyoming at the same time, equally well on all things.
I think those are good answers, Mr. Curley. I bemoan the loss of civility in the legislature and the factions that have developed more recently. I'm not sure how this really plays into that, because unfortunately, you really do count votes, and if you're trying to pass an amendment, you kind of are looking for the big bang for your buck. Who do I have to go talk to? All right, and if I got people that have 10 times the vote of another person, I'm going to go talk to them.
Yeah.
You know, Ms. Baumann.
I would just like to point out on page 6 of our table that shows the weighted legislative votes. Niobrara does indeed only get a quarter of a vote, and Hot Springs gets a half of a vote. From there on up, Weston, Washakie, Crook, Platte, and Johnson all get 3/4 of a vote. And then everyone above that only gets 1 vote. So there's not one senator with 10 votes.
Okay.
The most one senator can have is 1 full vote.
Thank you for
So
that.
I think the discrepancy is maybe not as much as what's being portrayed.
Fair enough, thank you. Mr. Co-Chair.
So with the follow-up to your question, Chairman Case, so part of this to me is the voice of the community, having that representation. And so wouldn't you agree that in response to that quarter vote, you also have that voice on the floor? And more importantly, my other question about committee, if they're in a committee, they do receive that full vote and have that voice for the community and committee. And so that's where I would see the difference. I just wondered what your comment would be.
That's what our plan proposes. The weighted vote on the floor, and all votes being weighted equal, so call it one, unity in committee and for other purposes. But that's really up to the House. We put it that way in the proposal because we think that maximizes the whole point of sending someone from a small county with a weighted vote, less than unity. The very problem of not having all votes be unit votes, I refer again to the professor's article that I'll submit. It's withstood federal constitutional challenge.
For counties, yeah.
Right, but the principle is the same. If it's constitutional there.
Possibly I see that. I'm not sure, but I get your point, yes.
Right. Thank you.
Thank you.
Thank you, Representative Knapp.
Senator Bowman.
Thank you, Mr. Chairman. So following up on the concept of not having weight votes in committee, I mean, would that not compromise the entire basis of what you're trying to achieve here, and that you're trying to have equal weight, one person, one vote, acknowledging that, but we just kind of ignore that in committee, and committees are important. You know, you can pass or kill legislation, so just a little bit more discussion on that. How is that construct retain the one person, one vote concept we're trying to attain here? Are you suggesting we change maybe how committees work, or, I mean, there's got to be some, a little bit more discussion there.
Mr. Curley.
Mr. Chairman, in response to the senator's point, I think he's, along those, put his thumb exactly on the vein that's thriving, and that's run the right place. But it is my take, and I'm only one person, make errors all the time, but the way I read the history of apportionment law, the issue really is, if you do weighted vote on the floor, full vote, equal vote in the committees, Does that violate the due process in the second clause of the 14th Amendment? Case law says no. More modern case law than the cases from the 60s and early 70s that said there'd be a problem with that. That's the question I think you want to ask. That how you want to do it, though, if I was in the legislature, I'd have a vote, but I have a sense that a lot of this requires the common sense of the people that go to Cheyenne.
That's where you might have a problem.
Yeah.
That's where you might have a problem.
I could use this word if I, are you telling me there's a dearth?
Well, I really do appreciate it. Any other questions from the committee, Senator Boner?
One more follow-up.
You bet, absolutely.
It's talking about the importance of committee, our leadership team appoints committees and who's on them. How would you imagine leadership elections going in this? Would that be weighed too, or would it be one vote for every legislator?